Good morning and welcome to the webinar on why proposed South Dakota Constitutional Amendment W is wrong for South Dakota. I'm Nathan Sanderson. I'm the Executive Director of the South Dakota Retailers Association. We've got about 4,000 members around the state of South Dakota, and our association is part of a large coalition of organizations, we're nearing 40 members now, that oppose the proposed Constitutional Amendment W. Today's program is going to feature a presentation by David Owen. David is the president of the South Dakota Chamber of Commerce and Industry, and he chairs the W is Wrong Coalition. Now, a couple of notes before we start the presentation. There's a note-taking version of the PowerPoint presentation available in the handouts area on the side of your screen. There's a box there with handouts. If you click on that link, it'll bring up a writable PDF. Also note that all of the phones of the participants are muted, and so we won't be hearing any background noises. We'll have a question and answer period at the conclusion of the presentation. If you'd like to ask a question at any time during the presentation, go to the chat box on the side of your screen, type in your question, submit that, and then at the end, I will read the questions out loud, and David will be here to provide the answers. Now, to begin the W is Wrong webinar, I'll turn the presentation over to David Owen. Here you go, David.
Thank you, Nathan. Let me take a minute and welcome you to the South Dakota Retailers You've got big shoes to fill. We were all friends with Sean, and when he was stricken, we all shared grief over that tragedy. I will tell your members who have dialed in, I've worked with Nathan Sanderson on projects, and they couldn't have found a better person to fill those shoes. So the Chamber looks forward to working with you, and so do I on a personal basis. Let's start with W is Wrong and do a little background. How'd we get here? In 2016, Represent US poured in about $900,000, and some of their friends poured in close to an equal amount and spent $1.7 million to pass IM-22, and they were successful. IM-22 did a number of things. It adjusted contribution limits, it addressed and eliminated gifts from lobbyists, and created publicly funded campaigns. A group of legislators and others took it to court, where the circuit court said this is most likely unconstitutional and enjoined it from becoming law. The 2017 legislature looked at it and said there's too much here that is wrong. And so they passed parts of it, including a lobbyist ban, or a ban from lobbying for 2 years if you've been in public service. They put gifts, limits on gifts you could give legislators, created an ethics commission, and took out the effective parts of IM-22 and repealed the rest of it. I would note, well, let's do this. The last point on your slide, the folks that Represent US were angry at that, and so they poured in about $370,000 in 2017 to put this back on the ballot as a constitutional amendment. We hear from them that the repeal was wrong. However, I would point out, before we go through the details of Amendment W, that IM-22 had publicly funded campaigns. There's no support for that in South Dakota, and they know it because they didn't put it back in this version. And so without a severability clause, there was almost no choice. But publicly funded campaigns don't fit our politics and aren't part of W. And so let's move forward and see what is W. My dad taught me early in life there's nothing more stubborn than the fact. And the next slide goes through some facts about Amendment W. It is 8 pages long, 3,329 words. Our Constitution's a fairly long document. It's 80 pages, but when you're adding 10% to it, that's not an amendment, that's rewriting the Constitution. It creates a non-elected tribunal that functions really as a fourth branch of government. In fact, the text specifically says, notwithstanding Article 2. What's Article 2? That's the one that says the powers of the state are divided between the executive, legislative, and judicial branch. So this is beyond those three. This new amendment creates an article that functions distinct from it, and even more directly. And I read from the text. In case of a conflict with any other provision of the Constitution, this article shall control. It uses similar language in other places. A total of 3 times it says, notwithstanding any other provision of the Constitution, and one says, notwithstanding any other provision of law. This is clearly designed to take over and suppress other parts of the Constitution as their way of making it automatically constitutional. The problem with this is it's going to take another statewide vote if to correct any part of this, no matter how small that is. The next section, 2 or 3 slides, we won't dwell on much, but it changes the contribution limits. Now, quite honestly, most of the members of the South Dakota Chamber, especially the board, don't mind that they have to write smaller checks to campaigns. Here's the problem, and you can see on the screen, $500 limit for local races, $750 for Senate, and it goes up to $4,000, which is the current limit for governor. It puts these limitations in the Constitution. So echoing the point I'll make throughout that I just made, if we decide those limits are too large or not working, not allowing reasonable campaigns, if you want to change political limits, the legislature can't do it. You have to have a statewide vote. The most pernicious part of this is what it does to political parties. It cuts the contribution level in half, but more of a threat to the current political system, it says the local chapters have to be included with the state chapter. So if you're used to helping your county, Republican, Democratic, Libertarian Party, and you write a separate check to the statewide party, you can't do that anymore. And again, if we're going to change that, it's a statewide vote. All right, let's look at this non-elected state government accountability board, which I will refer to as a tribunal. The Ethics Commission created in 2017 following the dictates of IM-22 has 5 members and they're all previous judges. By the way, they've had 3 complaints filed in a year and a half. This Amendment W would create a board with 7 members, 2 appointed by the Supreme Court, 2 appointed by the governor, 1 from a list by the speaker, the other from the minority leader. Those 4 appoint 3 more, 2 of which have to be non-lawyers. Perhaps hard to argue with that. Each of the 7 members has to be with the same political party so we don't get people switching parties to get on the commission. Here's the most amusing part, almost of the entire 8 pages. Each of the members of the non-elected tribunal is expected to fill out a financial interest statement, and if they have substantial interest in a matter that is before the board, that's a conflict of interest. So members are expected to recuse themselves from matters that they have a conflict of interest, and you see in red, unless, and this is text from the amendment itself, unless the board members' vote is necessary to resolve the matter. So it looks to me, in a cynical observation, like they want to stamp out conflicts of interest except their own, and members of the board recuse themselves except when their vote will determine the outcome. The next slide has the areas of law that this non-elected tribunal is empowered to deal with. I won't read through all of them. There's about 10 of them, and this is an expansive set of legal situations that almost duplicates the Attorney General. More dire is the fact that they can pass rules subject to the rulemaking procedure. Please know that that only requires public hearings. We have a rulemaking process when laws pass the legislature. These won't have to follow any of that. Let's talk about the rules that this group could pass. They deal with conflicts of interest. And so it is possible that this non-elected tribunal, looking for conflicts of interest because they deal with all public employees, state, local, teachers, elected officials that are on the ballot, including precinct chairs. So let's imagine that they want to come up with a rule that you have to disclose. If you have a government contract, you have to disclose your family members' financial interests. Nathan's pointing to something. If I serve on a local appointed city council, will this affect me? No, actually, to be fair to the amendment, which I have no interest in. No, it applies to people that are on the ballot other than congressional folks and are directly employed. And so if you're appointed to the library board in 2 dot, this you're not subject to this. Thank you, Nathan. This idea that if you have a contract with the government that your family has to disclose their financial interest isn't so far-fetched. Those of you that were around a decade ago, we took on what was then known as Initiative Number 10, which we branded the gag law, which required exactly this kinds of disclosure. This board can do it. The legislature can't repeal it. The governor can't veto it. After a few hearings, they could make it law. 3 members of the board are needed to do what's on the screen next, and that's initiate an investigation and issue subpoenas. People are allowed to complain to the board anonymously, so you're not going to know till later in the process, perhaps who you've been accused of being. This slide answers the previous question. The board has control over any elected or appointed official, judge, or employee of the state or local government. I may have to revise what I just said about appointment. That's the problem with 3,329 words. Every time you read it, you learn something new. I know it applies to employees, and you see a list of them. And elective offices, non-federal, which includes really minor offices like road districts. I will do the research on the appointed official part of that and make sure that Nathan and Donna have that answer. Let's talk a little bit about Amendment W's forced appropriation. It says that this non-elected tribunal will be funded with an annual appropriation of $389,000, which increases every year with inflation. Can't be vetoed by the governor, not subject to review by the legislature. In fact, there's a whole paragraph of what to do if the legislature refuses to appropriate the money, and the Constitution will then force the treasurer to put the money in their account. We'll argue all day long the $389,000 could be better spent on schools, on law enforcement. The Ethics Commission that was created before has needed nowhere near $389,000. And on top of this, the tribunal has the power to levy fines, administrative powers, and hire staff. The board has the right to intervene in civil actions involving government agencies, and you can read the instrumentality alleged in violation mandate under this article. And most important, the last few words in green, or the sufficiencies of resources provided for the board's implementation and operation. There's really no other interpretation of this than the board gets close to $400,000 as a mandate and can go to court for more. No other state has an ethics commission even mentioned in the Constitution except Florida and Oklahoma, and theirs make reference to an ethics commission but leave the appropriation and leave the rules control in the legislature's hands. It also puts kind of minutia in the Constitution, and I won't dwell on this, but there's a paragraph there that says you can't change or limit the initiative process without putting that change on the ballot to pass by a majority vote. There are some rules that we go through in the initiative process. How long is signature gathering? What forms that we are going to use? Do the proposals have to be printed on one page? Any of these things are rules which are now going to end up on a statewide ballot. The final part is to talk about the proponents of this. Represent South Dakota will claim that they're a South Dakota group. They are, but they're a ballot question committee only. They're not registered as an organization, nonprofit, LLC, or otherwise with the Secretary of State. They have no bylaws. They have no directors. They have no officers. They have no members. And so they are a ballot question committee that's trying to change the South Dakota Constitution. In 2017, they donated $369,000 to get this on the ballot. They claim that they only received $16,000 before the primary election. August 22nd, we'll learn how much more money they have. They did supply at the end of last year a supplemental report that's 191 pages long, and it has groups of people giving $1. They give $1 10 times. The total is 233,000. The last 8 contributors gave 50%. We haven't found a South Dakota address among them, but it's 191 pages, so I suppose there's 1 or 2 sneaking in there. This screen shows you what they've done to kind of confuse. While they're claiming they want openness, they're playing this game. There's 45 pages of people that give multiple $3 contributions. David Kirk gave $100 contributions 8 times. Thankfully, he didn't give $800 at once. We're gonna hear from the proponents that they've had thousands of contributions and the average is $12. This is about openness, and this is a method that's designed to hide the money. Amendment W creates a 4th branch of government that's really beyond the checks and balances, functions outside those checks and balances. The only way it's going to change is a statewide vote. It's a forced appropriation of money that could be spent otherwise. Thank you so much.
Thank you, David. We've had a number of questions come in. And so, David, to start with, is there any way or anyone who can overrule decisions made by this board, this tribunal? Can the legislature do that? Can the courts do that? How, if at all, are decisions overruled?
There really isn't. Notwithstanding Article 2 takes it out of the checks and balances, the phrase that says conflicts with any other part of the Constitution are controlled by the new article. The Constitution is superior to statute, so the legislature, the only way you're going to change this is to get something on the ballot and do a statewide vote of the people.
Okay, so there's a question we've got related to that. So how often would the public be able to change this if it passed? I mean, is this every 2 years when we go to the polls? How can the public change it?
The standard response would be you'd have the opportunity to ask the legislature to post the change during the next general election. You can get signatures of about 10% of the votes for in the previous governor's race, and a group could put it on the ballot. That would be a general election. The legislature also has the ability to put constitutional changes on the ballot and even schedule them for special elections. We had to clean up Marcy's Law, and that election was done in June at a cost of $200,000.
Okay, we've got, I think, a few different specific examples about ways that this proposed constitutional amendment would impact individuals. So, for instance, one of the questions is, if my son or daughter works at a state park for 3 months over the summer as a temporary or seasonal state employee, would they be covered or subject to this amendment?
As a state or county or local employee, yes. The rules are going to be dealing with those 10 areas of government, so it's a kind of ethics. They're not going to be passing human resource kinds of limitations on hours or wages or that kind of stuff, but they could, as another example, require state employees to show their income tax return so we know that they don't have conflicts. But any state employee, local employee, school district employee is subject.
So another question kind of along those lines. So is it true that a local teacher could be called before this unelected board or subpoenaed based solely on an anonymous accusation?
Yes. And presented with the charges, subpoenaed to appear, absolutely.
Okay, question along a little bit different lines. Are there other places in the Constitution that appropriate money?
Off the top of my head, there are formulas that we make reference to, and the use of some taxes, I'm thinking of highway money, is reserved for highway use. The particular appropriation, as far as I know, isn't mentioned. And by the way, the phrase "notwithstanding other provisions of the Constitution" exists to protect other funds like the sale of the cement fund. So we securitized our tobacco settlement money. It's only in that kind of narrow reference, but off the top of my head, other than things like the state aid formula, reserving money for highway use, the other thing we don't do is bind future legislators to specific actions. So this would be virtually unheard of.
Okay, very good. One last question that we've just had come in. So it says, the proponents of this measure talk about corruption. Is there a problem with corruption in state government?
No. In fact, when you ask them, give me a specific example of corruption at the state legislative level, they haven't been able to answer that. They do like to make reference to EB-5 and GEAR Up, which were embezzlement scandals of federal programs. They'll also admit that particularly IM-22 would never have caught those things. And as structured, Amendment W wouldn't either. And here's the point about that. They were crimes. The perpetrators got caught. They killed themselves, one of which tragically took his entire family with it. It's a whole different circumstance, and it's a convenient kind of bloody flag they're waving that isn't addressed by Amendment W and is quite honestly a little disgusting to be used as an example to solve a problem, quite honestly, we don't have.
Okay, thank you, David. That exhausts all of the questions that have been submitted. Again, David Owen with the South Dakota Chamber of Commerce and Industry. Again, I'm Nathan Sanderson with the South Dakota Retailers Association. This webinar has been recorded, and a link to this recording will be emailed out later today to anyone who registered for the program, and then also available on the Retailers Association website. Retailers Association, South Dakota Chamber of Commerce and Industry, again, part of a coalition of almost 40 different organizations in South Dakota who are urging South Dakotans to vote no on Amendment W this fall during the election. Thanks to everyone for participating, and have a great day.